You are listening to KSG podcast. This is a short, crisp, concise, exam-oriented, edited editorial for civil services aspirants. In this podcast, we are going to talk about Section 144 CrPC. Source for the content is the Indian Express. The administration of Uttarakhand's Haridwar district in April 2022 imposed prohibitory orders under Section 144 of the Code of Criminal Procedure 1973 in an area up to 5 kilometers around a village called Dada Jalalpur near the town of Roorkee. Section 144 was invoked after the Supreme Court instructed the Uttarakhand government to give a commitment that there would be no untoward situation or unacceptable statements during a Mahapanchayat that had been planned by Hindu religious leaders in the village on the 27th of April 2022. Incendiary speeches against Muslims have been made by Hindu religious leaders at such gatherings previously, including one organized in Haridwar in December last year. Now, talking about the Section 144 of the CrPC, this colonial era law, which has been retained in the code, empowers a district magistrate, a subdivisional magistrate, or any other executive magistrate empowered by the state government to issue orders to prevent and address urgent cases of apprehended danger or nuisance. The written order by the officer may be directed against an individual or individuals residing in a particular area or to the public at large. In urgent cases, the magistrate can pass the order without giving prior notice to the individual targeted in the order. Now, talking about the powers under the provision allows the magistrate to direct any person to abstain from a certain act or to pass an order with respect to a certain property in the possession or under the management of that person. This usually means restrictions on movement, carrying arms, and unlawful assembly. It is generally understood that an assembly of three or more people is prohibited under Section 144. When aimed at restricting a single individual, the order is passed if the magistrate believes it is likely to prevent obstruction, annoyance, or injury to any lawfully employed person, or a danger to human life, health, or safety, or a disturbance of the public tranquility, or a riot, etc. Orders passed under Section 144 remain in force for 2 months unless the state government considers it necessary to extend it. But in any case, the total period for which the order is enforced cannot be more than 6 months. Now, talking about the criticism of Section 144, affected parties have often argued that the section is sweeping and allows the magistrate to exercise absolute power unjustifiably. Under the law, the first remedy against the order is a revision application that must be filed to the same officer who issued the order in the first place. An aggrieved individual can file a writ petition in the High Court if their fundamental rights are affected by the order. However, aggrieved individuals argue that in many cases, those rights would have already been violated by the state even before the High Court has intervened. It has also been argued that imposing prohibitory orders over a very large area, such as was done in all of Uttar Pradesh during the protests against the Citizenship Amendment Bill, is not justified because the security situation differs from place to place and cannot be dealt with in the same manner. Now, coming to the court's ruling on Section 144, while challenges were mounted against the use of the provision in the pre-independence era as well, the first major challenge in the Supreme Court came in 1961 in Babulal Parathe versus State of Maharashtra and others. A five-judge bench of the Supreme Court refused to strike down the law, saying it is not correct to say that the remedy of a person aggrieved by an order under the section was illusory. In 1967, the court rejected a challenge to the law by the socialist leader Dr. Ram Manohar Lohia, saying no democracy can exist if public order is freely allowed to be disturbed by a section of the citizens. In another challenge in 1970, a seven-judge bench headed by then Chief Justice of India M. Hidayatullah said the power of a magistrate under Section 144 is not an ordinary power flowing from administration, but a power used in a judicial manner and which can stand further judicial scrutiny. The court, however, upheld the constitutionality of the law, ruling that the restrictions imposed through Section 144 are covered under the reasonable restrictions to the fundamental rights laid down under Article 19(2) of the Constitution. The fact that the law may be abused is no reason to strike it down, the court said. In 2012, the Supreme Court criticized the government for using Section 144 against a sleeping crowd in Ram Leela Maidan. The court said, and I quote, "Such a provision can be used only in grave circumstances for maintenance of public peace. The efficacy of the provision is to prevent some harmful occurrence immediately. Therefore, the emergency must be sudden and the consequences sufficiently grave." Unquote. That's it for this podcast. Thank you so much for listening. To join KSG India courses and to crack the ICE exam, visit ksgindia.com. You can also get a PDF of this podcast on ksgindia.com.